right, uh, let's go ahead and proceed. You want to make opening statements? The plaintiff starts.
Yeah, I'm sorry.
Started. I'm not sure.
Okay.
It's okay. So we're here on a trial involving a workers' comp case. As I understand it, you guys are going to have made certain agreements to try to streamline the case. So why don't we start with opening statements? Ms. White, you may begin.
Yes, Judge. We submitted our exhibits. Mr. Jose Casanova worked for Garda World. It's basically an armored vehicle company. When he sustained his injury back in—
How do you spell that? Garda World?
Garda.
Okay, World.
It's like your armored truck guys that go collect money from businesses.
Okay.
So he, on October 24th, 2018, he was a restrained passenger in an armored truck traveling between Tye, and Lubbock, Texas. It was a rainy day, traveling about 65 miles per hour. He was taking a nap when this happened, suddenly woke when his partner shouted, "Oh no," and the truck hydroplaned to the left and rolled onto the driver's side. Mr. Casanova banged the right side of his head on the passenger window during the roll. When the truck stopped, he did undo his seatbelt, which caused him to free fall towards the driver's side, striking the left side of his head, chest, left arm. And he began treatment regarding this workers' comp claim. There was an issue that came up about what are the extent of his injuries. We argued that they were more severe than what the carrier had accepted. There was a decision and order found on this under the which Mr. Poteet has in evidence, but the judge found that only the thoracic sprain should have been added to the compensable injuries. We are arguing that it's more severe than that. We're relying on the medical from his treating physician, Dr. Jose Fuentes, who did provide a letter of causation to support why the injuries should be part of the claim. And he did see a doctor referred by Dr. Fuentes that did a full evaluation on him and indicated that is one of the issues is he at maximum medical improvement and is there impairment rating? It is our position as of the date of that case hearing that he was not yet at maximum medical improvement. There was still treatment available to him that could significantly improve his condition. The judge at the administrative law judge found otherwise. And that is our position, judges. We believe those conditions should be related, and we have the medical provided in our exhibits to support that.
Okay, Mr. Poteet.
Yes, briefly, as Ms. White has indicated, there was an administrative hearing on this particular case, and the administrative law judge, did find that the compensable injury, and there were certain injuries that were accepted outright. There was a dispute over the following conditions. It's a thoracic sprain, and a left shoulder sprain, a concussion, tinnitus, disequilibrium, hearing loss, and cervical strain. The administrative law judge did find that the compensable injury should extend to and include the thoracic sprain. The remainder of those conditions, the administrative law judge found that there was not enough evidence for the plaintiff to meet his burden of proof. And so therefore, the administrative law judge held that those conditions were not related to the compensable injury. Then and so that's one of the issues, is the extent of the compensable injury. There's no dispute that the plaintiff was injured on the job. There's no dispute there. The question is just whether he has met his burden of proof. And that what happened in this case, and you will see in just a few minutes, the CCH, the contested case hearing decision and order, the judge outlines the evidence for you. And then she also includes her reasoning for finding that the compensable injury should extend to include that one condition, but not the remainder of the conditions. The designated doctor, there's a designated doctor, which is a state appointed doctor that was asked to opine on the issues of maximum medical improvement and impairment rating. And I'm sure you're familiar a little bit with workers' comp. And if I go over something that you already know, please let me know, and I won't bore you with things.
We don't see a lot of these cases. I have tried some workers' comp cases, both jury and non-jury, but they're pretty rare. So if you're not going to hurt my feelings if you want to go through the basics.
Okay. So in a case like this, at the outset, the carrier has to make a decision whether or not there was a compensable injury. And in this case, obviously, we did find that. Then we review the medical records and determine whether or not we're going to dispute any specific diagnoses. And that's what we did in this case, which led to a benefit review conference being held, and then ultimately a contested case hearing. The contested case hearing, what you will see when we admit the exhibits, that's everything that the administrative law judge had. We're going to give all of that information to you. In addition to that information, you're also going to get the written decision in order that was authored by the administrative law judge. After that happened, the plaintiff appealed to the appeals panel. And the appeals panel in Texas, they review the CCH decision in order, the contested case hearings decision in order, and decide whether or not to reverse it and remand it, reverse it and render, or they say, we're just going to let it go as it was. And in this case, they did not take any action. There is a very brief appeals panel decision that you will see, but it basically says we're not doing anything. We're going to let that CCH decision in order stand. The designated doctor is a state-appointed doctor that will address various issues based on a request from the parties. And in this case, we have a designated doctor who was asked to address only maximum medical improvement and impairment rating. The administrative law judge decided that she could not adopt that certification because the designated doctor included in his certification a condition which was not compensable. After you have a designated doctor's exam, you can have what we call a post-designated doctor required medical evaluation. And that's what we did in this particular case. And in this particular case, we had a doctor by the name of Dr. Dories, and he found that the claimant had reached maximum medical improvement on June 12th, 2019, with a 2% impairment rating. And the impairment ratings have to abide by the 4th edition of the AMA guides. And so what we're asking for today, Judge, is that you affirm or agree that the compensable injury does not extend to and include those disputed conditions. We're not arguing, we have not made a counterclaim on the condition that the hearing officer or the judge found to be compensable. It's only on those conditions that the plaintiff did not prevail on that we're here about.
So let me ask this. So the designated doctor, he had a condition that he found was related that the administrative judge didn't agree with. What was that condition?
A cervical sprain. And he included it, but I don't believe he actually said that it was related. So what happens is you fill out a form when you request a designated doctor, and it could be that designated doctor was asked to address diagnoses that were not necessarily compensable, and so he included it without giving any analysis as to why that should be included. So yes, there is one condition, and that is a cervical sprain, and you will find that in the CCH decision in order. That document, the CCH decision in order, will give you an outline. Obviously, what we always say in district court when you appeal a case from workers' comp into district court, the finder of fact, you, is allowed to look at the CCH decision in order and the appeals panel decision, but you're not bound by it. You can give it whatever weight.
Is it a de novo review?
It's kind of a modified, because you're informed of what happened at the administrative law. So it's a modified de novo review. You get to look at what the decision was underlying decision, but you then get to decide, okay, do I want to agree with that decision, or do I want to modify it in some way, or do I want to just completely reverse it? And that's the relief that Ms. Wyatt is asking for, is that you set aside the CCH decision in order and rule in the plaintiff's favor that all of these conditions are related.
Did the designated doctor find that the tinnitus or any of the other issues that you talked about earlier were related?
He did not.
Okay.
So the only one was the cervical sprain. And you can just I don't want to act like I'm a teacher or something on comp, but you can decide that one condition is related, the rest of them are not. And if that is the case, then the designated doctor does have a certification of MMI and impairment rating. The impairment rating that we're relying upon is a 2%. What the designated doctor provided was a 6%. And I think it might be a different date of maximum medical improvement.
And then was there another doctor that wasn't the designated doctor that related the tinnitus and the other things?
That's the doctor that Ms. Wyatt was relying upon. I think it's Fuentes.
Dr. Fuentes is the doctor.
And what was the impairment rating he gave?
He did not. Sorry, go ahead.
Sorry, go ahead.
No, you go ahead. That's your doctor. I'll let you do this part.
So Dr. Fuentes is the treating physician. You have to be, he referred her to Dr. Dion, who did the impairment rating and indicated that the claimant is not at maximum medical improvement based on those injuries.
How do you spell Fion?
It's, let me give you Dion, D-E-O-N. It's our exhibit 15.
Okay.
And she specifically only evaluated the injured worker to determine if he's at maximum medical improvement for all these injuries or not. And she said, no, he's not yet at MMI.
So if I agreed with that doctor, and I'm not saying I am, I'm just trying to make sure I understand the process here. If I agree with that doctor, then there would not be an impairment rating yet because he hasn't reached the patient has not reached MMI.
So what would happen in that case? It would have to be remand. You can make that determination that he was not at MMI as of the date of the contested case hearing, but he is now past what we call statutory MMI because his injury occurred on October 24th, 2018, and you reach statutory MMI within 2 years of that date. So he's well past the date of statutory MMI. So if you choose to do that, and that would be something that we would include it in a judgment for you. But if that's what you decided, and you would have to let us know what your decision ultimately is, so we can craft a judgment that is correct and binding.
Sounds like there's three possibilities here. I stick with the 2%, I go with the 6%, which is what the doctor said, or I say there's no MMI and I remand it back to the commission.
And that would handle two of the issues. That would handle the issue of maximum medical improvement, and it would handle the issue of impairment rating. But then you would also you need to make a determination on the compensable injury, which conditions you believe are related, which you believe are not related. So those are the three issues that you need to address. And as you consider on the extent of injury, as I said earlier, you can decide.
So let me make sure I understand. For compensable injury, for the state's designated doctor, compensable injury was cervical and thoracic. For the administrative judge, it was just thoracic. And then for Fuentes, what was the compensable injury, or Dion, I guess?
Actually, Judge, there's a list of conditions that the judge and the parties stipulated to at the contested case hearing that are part of the claim. And if it's multiple rib fractures on the left side.
Okay.
This is all in the decision. I'm going to pronounce this probably wrong, left pneumothorax, head contusions, rib contusions, and left shoulder contusions. Those were accepted without dispute. And then the judge added to that the thoracic sprain. I do want to clarify that the designated Dr. Kenneth Bales was not specifically asked to address what conditions were or were not part of the injury. He was just asked to provide an impairment rating. So he wasn't, his opinion on any extent of injury, I don't, and if I'm wrong, Mr. Petit, let me know, but I don't think the report of Dr. Kenneth Bales, he was specifically asked to address the severity of the injuries at all. He was just asked to look at what was already accepted. Yeah. So we added to that by having the claimant's treating physician provide a statement that added to the injuries. And to go back to your question, what are those? I will provide you those additional conditions. And that would be the left shoulder sprain, concussion, tinnitus.
It might be a good idea if we could just share screen the DNO with him, if I can figure out how to do that.
Well, let's before we get to that, I think beforehand you told me that you guys had agreed to pre-admit certain exhibits.
Yes.
So plaintiff's exhibits, what is agreed to?
Plaintiff's exhibits 1 through 16.
Any objection to 1 through 16, Mr. Petit?
No objection, Your Honor.
1 through 16 are admitted, and for Ms. Wyatt?
That's her exhibit.
I'm sorry, for Mr. Petit, the defendants, what exhibits do you have? 1 through 3. Any objection to 1 through 3?
No objection.
1 through 3 are admitted. Okay, so how did you envision this would work? You guys are going to show me the exhibits and argue them, or how do you guys?
Well, I think what we have done in the past is we have just made our arguments, and then we present you with the evidence, and then you review it and make your determination. And
okay.
Then, and I don't know, because I think her exhibits are about 200 pages. Mine are about 130 pages. I'm not sure that this is something that you can do while we sit here. And so it's essentially what we wanted to do was just do argument. You know, we did it. This has really been a.
Why don't you do this? Why don't you highlight the pages that you think are critical for me to look at, and then I'll read them, and then maybe we reconvene if I need to, or however you guys want to do it. But my thought is I don't want to really read 300 pages with you guys just sitting there. So
I'm agreeable to that. If we just reference what exhibits we're relying on, that'll just point you to where you need to focus, Judge.
Okay. Which ones are those?
Okay, in our exhibits, it would be number 16, number 15 and 16. Specific.
Okay. And what do I need to be looking for there?
So exhibit 16 is under workers' comp, where we need to have a letter of causation that supports our injuries that we're trying to pursue. So that is his treating physician. That's his main Dr. Fuentes, that's providing that specific letter outside of all the diagnosis and medical records. The doctors separately provided this letter. And then Dr. Dion, that's exhibit 15, is the MMI and impairment rating that we were relying on at the time that indicated that he was not at maximum medical improvement. But specifically, Judge, for the injuries that we're pursuing that we would like for you to find are part of the injury, we're relying on exhibit 16. And it's 5 pages.
Okay.
It sums up everything of the other exhibits.
Perfect. Okay. And what about defendants? I guess all of them.
Well, I'm gonna try to narrow down on exhibit 3 some page numbers for you.
Okay.
Exhibit 1 and 2 are fairly brief exhibits. That's just the CCH decision in order, as well as the appeals panel decision. So on the rest of it, let me just give me just a second, and I'll give you page numbers. That way you don't have to flip through 130 pages to get to what you need to get to. So if you'll just bear with me for a second. Okay, so page 28 of the defendant's PDF. And that goes through. And just so you know, that's the designated doctor's report. That's the state appointed doctor is starting at page 28.
Okay.
And that runs through, let me tell you the last page of that.
$28 through what?
Yeah, I'm trying to get there. Sorry.
It's okay.
28 through 36.
Okay.
And then the next exhibit,
And Kevin, these are the PDF numbered pages, not what's listed on the page, correct?
right, the PDF number. So that way you just can type in the number of the PDF and go straight to it. The next exhibit is going to be Dr. Dory's. I can find this real quick. Okay.
I think 49.
Yeah, it starts at page 49. That's correct. Thank you, Kim.
Okay.
I'm glad somebody here is more technologically advanced than I am, which that is a very low bar, by the way, if you're more advanced technology wise than me.
And I'm doing all this on my phone. No, I'm kidding.
Wow.
I'm kidding.
That would be impressive.
That would be impressive, but I wouldn't be surprised.
I'm kidding.
So now I just got to get to the last page of that. And these are really the two that you need to look at on mine in addition.
It's 96.
Okay. All right. So then after 96.
What? So 28 through 36 and 49 through 96.
Yes. Now on the 49 through 96, most of that there's a history of the medical treatment that you probably won't be interested in. As you get closer to the beginning of it will be a form that has the doctor indicating what the impairment rating is and what the maximum medical improvement is. Then there's a list that's probably 20 pages long of a summary of the medical records. You can basically skip that and go to 96 and work your way back up to see the doctor's opinions.
So that's 68. He starts talking about the certifications on page 68.
There you go. Thank you, Kim.
You're welcome.
Why don't we do this? Why don't you email me directly this stuff, because I haven't gotten it. Email me the exhibits directly. I'm going to go off YouTube and tell